Well, good afternoon. I'm John Mendenhall, and I'm the chairman of the Endowment Committee of the Union United Methodist Church. And I want to thank everybody joining us today, both in person and online, as we present the estate planning seminar. Before I introduce Ms. Lisa Lee Smith, that's going to be presenting the seminar today, I'd like to recognize some of our committee members. So if they could please stand up so I can people can introduce. Come on, Felicia. All right. And I want to thank everybody that's on the committee. You know, our committee does work hard. They sometimes it's good times, when we're able to disperse money and give money out to support the missions of the church. But then when the market's not doing so well, it's not as fun. So, but they do work hard, and I appreciate everything that they do. The Book of Discipline of the United Methodist Church, there's a couple passages in there, paragraphs that talk about the endowment. And I just want to read those real quick. It says that when we talk about the endowment, we have to emphasize the need for adults of all ages to have a will and an estate plan, and provide information on the preparation of these to the members of the congregation. We need to stress the opportunities for church members and constituents to make provisions for giving through United Methodist Church, institutions, agencies, and cases by means of wills, annuities, trusts, life insurance, memorials, and various types of property. So, the endowment's not only about the missions of the church, but it's also about the wealth, the financial well-being of the members and the church itself. So, just try to remember that as, anytime we do some givings to the endowment, it's about the support of the church and the mission. So remember us in your givings. So, now I want to introduce our speaker, which is Miss Lisa Lee Smith. She is a local attorney from Chapin, South Carolina. She is also a local girl who graduated from Irmo High School. She graduated from Clemson University, and in order not to show any favoritism, she also graduated from the Law School of University of South Carolina. So, she favors everybody. So, she's got 25 years of experience in the field of law, and she's been involved in a lot of local organizations, a lot of community events, and but her primary focus in law right now is real estate, probates, and estate planning. So I'd like to introduce you to Miss Lisa Lee Smith.
Great. Thank you so much. I may give you your notes back, if that's okay. Thank you so much, and thank you to all of you for being here, for being online, for the church for inviting me. This is such a privilege and a pleasure for me. I really enjoy talking about estate planning. I do it most days of the work week with someone in my office, and but it's nice to get out and do it with a group. And so let's dive right in. The first thing that I want to do is go over some basics of just some terminology. Let's see if I can get that to forward. It went to sleep, maybe. There we go. All right, great. So just some basic terminology that I want to go over with you. First of all, when we talk about estate planning, some people have the reaction to say, well, I don't have an estate, because they think of an estate as being, a big tract of land, a lot of property, a lot of wealth. Well, your estate is anything that you own. When you pass away, that is your estate. And it could be very little or it can be a lot. It's still an estate. So estate planning is for everybody, not just the super wealthy. And so that's your property. And estate planning is about how that property gets from you to your loved ones, or the charitable interest, or the church, or whoever you want to leave it to after you pass away. How do you get the property that you own to go to the people you want to benefit? Those people we call your beneficiaries, okay? Your loved ones, your church, your charities, the people you want to benefit are your beneficiaries. And just in really broad terms, you can transfer that property by lifetime gifts. You can make charitable gifts during your lifetime. You can pass that property by probate, which I'm going to define a little further here in a minute, or non-probate. All right, so let's talk about non-probate and probate. So anything during your lifetime, you take care of that during your lifetime, and that's a wonderful way to transfer your property. But planning for when you pass away, how your property is going to pass, we need to understand probate and non-probate. So, see if I can, I must not be pointing quite at the right thing, I'm sorry. Okay, oops, I did it too much. Here we go, Probate Administration. You may hear a lot about people saying, you want to avoid probate, okay? And part of what we're going to talk about today is there's a place for that. There's a time and a place for avoiding probate. But probate administration has a purpose, and there are times when it's what's needed to best transfer property. So we'll look at when are those times. But basically, probate administration is what happens after you pass away. And in probate, you can pass property with a will, or if you don't have a will, then the law is going to determine how your property passes, and that's called intestate. So if you have a last will and testament, you're passing your property testate because you have a last will and testament. If you do not have a will, your property is going to pass to your beneficiaries intestate, and that will be determined by the law. Some of the things that happen with probate administration, so you know what you're planning for, there's court supervision, there are requirements for inventory, it's a public process, there can be an accounting done. So the probate process is an administrative process that happens after you pass away. It can happen anywhere from 8 months to several years to finish, but typically it finishes in about a year. And the court is supervising the distribution, the inventory and distribution of assets, either according to a will or according to the law. There's a public record for it. Many people go through this process without ever having to go to court. Okay, so appear in front of a judge. That does happen sometimes in probate, but probate is an administrative court primarily. It's not going to involve a hearing unless there are contested or disputed matters that need the court's involvement. So that's the probate process, and the reason you have a will is because you want to direct where your assets, where your estate goes in that probate process. Now, the other way, the non-probate side of passing property, is worth spending some time on, because there are lots of things that you can do that are considered estate planning that don't involve making a will. All right, we'll get back to the will, but let's talk about this non-probate options, because there's a lot here that can save money and time and effort and administration if you can pass those assets directly to beneficiaries. So I've illustrated them here on the slide, just really dealing with ways to get your estate from the decedent, that's you, the person who has died, to the beneficiaries. So real estate. I want to pause on this because real estate, if you, this is very often happens with spouses, but if you own your property jointly and it has the right of survivorship, then when one spouse passes away, that property is automatically owned by the survivor. Survivorship rights are very powerful in determining ownership. So if you have them in your deed, then your joint owner gets that property immediately and automatically. That asset doesn't go through probate, doesn't get listed on the inventory, just automatically is owned by that survivor. Vehicles, if you jointly title your vehicles with an or between the names, Jack or Jill own this car, then when one of them passes away, the car is automatically owned by the survivor. That or acts as a survivorship tool. So setting up the way you own your property now can impact where it goes later. And a lot of estate planning involves looking at your assets. What do you own? How do you own it? How is it titled? And then, is there a better way to title it? Can it get to your beneficiaries more efficiently? Or does it need to go through probate? A couple of other things, I'll just run through what's on the list here, and we'll circle back to some of these. Personal property is automatically presumed to be jointly owned between spouses unless it is treated differently by the spouses. Annuity and retirement plans, really anything that you can name a beneficiary on, and a contingent beneficiary, those are ways to keep that out of probate. Let it go directly to those beneficiaries. Sometimes you don't want it to go directly to a beneficiary, let's say, because if your beneficiary is a minor, right? If your beneficiary is a 10-year-old child, well, you're not going to list that child as a beneficiary on a retirement account because the child doesn't have the capacity to own that at that time anyway. You're creating some other issues. That would be an instance where if you're trying to get it to that child, you want to look at some other way of doing it, a trust or maybe a trust in the will to get to that child. Bank accounts can be set up joint. They can be set up transferable on death, that's TOD, or payable on death, POD. Different financial institutions use different words for their particular options, but bank accounts, CDs, any of these things can be set up so that in the name of it itself, in the title of the ownership, you designate a beneficiary. So life insurance, of course, beneficiaries, and putting assets in a trust is another way of keeping them from going through probate. So we'll get back to this a little bit more as we go through the presentation this afternoon. So the main question I kind of want to start us all with, and really the take-home question for you is, are your important legal documents in order? Do you have your legal documents in order? Do you know where they are? Were they executed properly? Do you know what they do, what they mean? I meet a fair number of people who come to me with prior estate documents. Many times it's people who have moved here from another state, and they're just wanting someone here to look over what they have, but they really don't understand the documents they already have. And so I want you to understand the documents you have. I think that's important. And I don't think you should be signing documents that you don't understand. So my goal is clarity in your understanding of the documents that you can have and the ones that I would recommend that everyone have, okay? So let's talk about power for a minute. So when I talk about power, I'm talking about your ability to decide things for yourself. All of you decided to come here today. You, of your own free will, decided to come here and sit where you sat. You had the power to do that. You have the power to sign a document or not sign a document, to ask for something to be drafted a certain way, to pull money out of an account, to put money in an account. This is the kind of power that I'm talking about when I talk about who has the power, all right? So during your lifetime, you have the power until you don't, okay? And some of the instances where you can lose that power, that autonomy to make those decisions for yourself, would be an easy way to think about it is if you just became unconscious. Let's say you went into a coma, All right, well then you no longer have that capacity to sign a document, to make a decision, to go somewhere. You've lost that while you're in a coma. Certainly dementia and Alzheimer's, very often a gradual onset of the losing of capacity can happen during your lifetime. You're still alive, but you are losing or have lost some capacity that gives you power. So during your lifetime, I put the you and the loved ones. You have the power, and then who's going to get it when you lose it? Or if you lose it, who has it? In South Carolina, we have a procedure in the probate court for guardianship and conservatorship. This is a procedure where loved ones can say to the court and bring proof from doctors, my loved one is no longer competent. We need this person declared by the court to be incompetent so that a conservator can be appointed or a guardian can be appointed to manage their affairs, to make decisions for them about where to live, to sell their property, to pay for their care. Whatever decisions need to be made, the probate court determines what powers to take away from the person and give to a guardian or conservator. It's a public proceeding. It's a very difficult proceeding. I don't do that kind of work, but I usually refer people to several other lawyers who really specialize in that area. But it's hard. It's a difficult procedure for a family. And part of the reason that you do prepare a durable power of attorney and healthcare power of attorney is those are documents that help avoid the need for that guardianship and conservatorship if you were to become incompetent or need assistance in making decisions. While you have capacity now, while you know who you trust, who thinks similarly to you of your friends and loved ones, who you want to have that power when you need them to. You do a power of attorney for financial matters or healthcare power of attorney. Joint owners of property, that's another area where when you jointly own something, you're giving up some power. If you were to just give someone a half interest in your property, you have now given them some power. You can't sell it without them, right? And then a trustee sometimes gets involved as having power. If property is in a trust, then you would have a trustee with some power. So thinking about this in terms of power and during your lifetime is a good way to kind of think about, okay, why do we have these powers of attorney and why are they important? So let's talk first about the financial power of attorney. Oops, I skipped over too much. And you all have a handout that's got information on the back and the front, and that's really to take home. And but I'm not going to go like straight through the handout, so that's really just for your take home. But some of it you will recognize on the slides as well. So let's talk about the financial durable power of attorney. This is a document where you designate an agent and alternates who have the power to make financial decisions for you, who have the power, this agent has the power to sign your name. Think about it in terms of you've got a check that comes in the mail and it's made out to you. Your power of attorney agent, if they are a general, durable power of attorney agent, they can endorse your name on the back. They can sign your name to a contract. So this is a very powerful thing that you are giving this agent this power. Couple of really important requirements for this. You have to be confident. You have to know what you're doing, know who you trust. You have to understand what you're doing. Got to have 2 witnesses and a notary on the document, and they cannot be interested in the document, okay? They can't benefit from it. So it's something you need to sign and execute in a formal way and make sure no witnesses are interested in it. This document also gets filed in the county. So it gets filed in the Register of Deeds office in the county that you reside in. That is because if your agent went to a bank and was trying to do something with your account, the bank would need to be able to look and confirm in the Register of Deeds office that that is still a good power. So if you have one of these powers and then you change your mind about that agent, you need to record something else that cancels it. So this is the one document that gets recorded during your lifetime. Many people think that wills get recorded during your lifetime, and in some states they do, but in South Carolina they do not. The only one that gets recorded during your lifetime is this durable power of attorney. I'm going to skip to that next slide. The healthcare power of attorney. Oh, the other thing I was going to say about the financial power of attorney is that it specifically states the power that is given. So you only give the powers that that document says. In other words, there's no implied powers in that document. You don't read into it more powers than it says. It has to say exactly the power you're giving. So sometimes updating those is important, especially if what you have is a very old power of attorney that was very broad or vague, but you have some things you know very specifically you want your agent to do. That's an instance where updating that is a good idea. So healthcare power of attorney, you are appointing, again, agents and alternates, and you're also giving some advanced directions about what you would want to happen with regard to life-sustaining medical treatments if you have a terminal condition that is expected to result in death in a relatively short period of time, or you are in a state of permanent unconsciousness. These are what I'm going to kind of generally call more end-of-life decisions related to healthcare, life-sustaining treatments, and artificial nutrition and hydration. So this healthcare power of attorney has a component of it that is specifically about these advanced directives for end-of-life decisions, and then it is very simply just appointing who speaks for me to the doctors and nurses if I'm unconscious or incompetent, which could be a temporary thing, could be not an end-of-life decision that needs to be made. It could just be, are we doing this surgery or that surgery? Are we taking this antibiotic or that antibiotic? And for some reason, the doctors don't think you're in a place to make the decision. This tells them who to listen to. And it's really helpful in what can be a very stressful time for loved ones when a family member is unconscious, let's say from an accident, and to know who speaks, to speak with one voice for all the competing voices and noises that come up in those stressful times, and the order of priority that people get to speak. You put your agent's phone numbers and addresses in that document. This is a really helpful document to have. And I recommend to people that they talk to the people who are their agents. Make sure that your agents are people that understand your approach to medical care. Are you someone who always wants a second opinion, or at least before you have any surgery? If that's kind of your rule, or you have some rules in your mind about how you want healthcare decisions made for yourself, talk to the person you're appointing as your agent and make sure that they understand, because in my experience, most people, and I know people have varying experiences here and some very traumatic, but most people who are serving as an agent are trying to figure out what the principal would want them to do. They've been given a job and they want to know what would he or she have wanted me to decide for them in this moment. The more you've talked about it, the better. And I know it's a difficult conversation, but really important and such a gift to have had those conversations if they turn out to be necessary. There is also something called a specific or limited power of attorney. You see these sometimes dealing with a specific transaction. So let's say you're going to be unavailable, you're traveling, and there's a closing that's happening. You can give someone a power for 90 days to sign closing documents at a lawyer's office for you. That's a specific or limited power of attorney that is situational. The two that I recommend everybody have are the durable power of attorney and the healthcare power of attorney. Those two documents will help avoid any need for a guardianship or conservatorship, any need for you having to be declared incompetent before someone can help you, and especially if you know who you would appoint and the alternates, it simplifies things for your loved ones and friends who you're appointing, so they know the order in which they're serving. Who's first up? Who's got primary responsibility and who's the backup? It organizes your loved ones around your needs based on your decisions. The other document that is often done with the durable and healthcare power of attorney, let's see if I can do that. I'm sorry that I pause on this every time, y'all. Let's see. There we go. Is the living will. And if you go to the hospital, check into the hospital or doctor's office, they will very often ask you, do you have a healthcare power of attorney and a living will? And they want you to say yes or no, check yes or no. The living will is unfortunately called that because it's not a will at all, and people often think they have a will when they have a living will, and that's wrong altogether. So the proper name of a living will is a declaration of desire for natural death. It doesn't say living will anywhere on the document, okay? But that document is a very narrow, specific set of circumstances and a statement that says if two doctors certify that I am in the dying process, I'm permanently unconscious, or I have a terminal condition that could result in death in a relatively short period of time, and it even says these two doctors have to both have personally examined you, one has to be the attending physician. I mean, it's a set scenario that the medical field is very familiar with. And then it is you declaring in this document that you don't want the dying process prolonged in that scenario. You just want to be provided with comfort care. So that's what a living will is, this declaration of desire for natural death. It does have a couple of places to initial regarding artificial nutrition and hydration preferences, but it's a very focused subset of healthcare issues. So if you have a healthcare power of attorney, think of it as covering all healthcare issues, and you have a living will, it's covering this one scenario right here. If the living will applies, then it controls. But as to everything else, the healthcare power of attorney is there. So if you're only going to have one, I recommend it's the healthcare power of attorney. If you like what the living will says, then I recommend getting it in place. It's a chance for you to go ahead and say what your preferences are. It makes it easier for your loved ones in those scenarios if you've made those advanced directions. All right, so let's switch gears then. Whoops, I might have hit it twice. Okay, so who has the power? Who has the power after you die? Okay, after you die, who has the power? Well, it's primarily the documents you leave behind or don't leave behind, okay? The absence of documents as well could be that power. But the documents you leave behind, the state of your affairs when you pass away, impacts how and who your assets pass to. The law is going to come in where the document, to interpret the documents, and the law is going to come into place if you didn't have a will. For instance, the law is going to determine who gets your assets. Let me talk just a minute about the last will and testament if you don't have a will, right? So Part of the reason you do a will is because what the law does if you don't. If you don't have a will and you are married with children, when you pass away, your property goes half to your spouse and half to your children. That's that intestate law. If you're married with no children, it is going to your spouse, all right, 100%. But it does have to go through a little bit more of more complexity in the probate process. But it will get to your spouse. Essentially, the law is looking out for your spouse and your children, and then beyond that, if you don't have a spouse or children, the law looks first up the family tree to your parents. Are your parents still living? It'll pass it up the tree. And then out, it'll pass it to your siblings. It'll pass it to your nieces and nephews. You know, in very large families, this can get complicated. Figuring out who on the family tree inherits, especially if someone doesn't have a spouse or children, you can see how it ends up being some kind of distant relatives who are benefiting from that scenario. So that's what the law does if you don't direct what you want to happen. So a couple of things I just put on here about the documents you leave behind. If you left jointly owned property, well, then it depends. Does it go automatically? Does it have that right of survivorship where it goes to the other party who's owning it with you? Or did you leave something owned half and half? I see this a lot in deeds that people don't know what their deed to real estate says. And the deed just says the property is owned by Jack and Jill. And then it's silent after that. There's no by right of survivorship, joint with right of survivorship. That survivorship language is not in the deed. So what happens is when one spouse passes away, a half interest in that house has to go through probate to get to the spouse anyway. And what's worse than if there was no will, a half interest in that property has to go through probate and it goes half to the spouse and half to the children. It's unnecessarily complicating the process of passing your assets when if you just look at your deed and see if you've got right of survivorship in there, you could simplify that. We do a lot of deeds for people who, as soon as I explain that to them, they realize that's not what we want. We wanted right of survivorship. But a lot of times in real estate closings, that topic doesn't come up because it's an estate planning question. And the real estate attorney doing the closing just knows to put it in both names, and not all lawyers talk with the people about estate planning questions at that time. Beneficiary designations in all those types of policies and investment accounts, retirement accounts, those things are going to control. That's the document you left behind is a beneficiary designation. So if the beneficiary survived you, that's done. That's easy. If the beneficiary didn't survive you and you don't have an alternate, then that asset is coming into your probate estate and it's going to go according to your will. So again, the reason you need that will is to capture those things that you might have a plan A. Plan A on your life insurance is that you're leaving that to your spouse. But if your spouse predeceases you and you don't have an alternate that did survive you, that life insurance has got to go somewhere. It comes into your estate and follows whatever is happening in probate. Two important things on the last will and testament that I want to pause on here is you've got to be able to find the original after someone passes away. And it has to be executed properly. So these are two big mistakes. People think they're getting their documents in order. They get a will, and then they lose the original. They can't find it. They've moved, they unload the boxes, and it's not there. Okay, a copy will not do. I've only seen one time in my 25 years of doing this where a copy was recognized. It was a house fire, and everybody, they had to get affidavits from all kinds of people to prove to the court that that was, the person died in the fire, and so it was a very unusual situation. Courts do not want to recognize a copy. We have a law in South Carolina that presumes if the original can't be found, you didn't want it to be found, because that's one of the ways you can change your mind. Just throw it away, and it's no longer your will, okay? So keeping up with the original is really important, and then the proper execution on a will is really important. 2 witnesses, one of whom can be the notary, or you can have 2 independent witnesses and a third person be the notary. Either way, those 2 or 3 people should never be related to you, okay? So if a beneficiary happened to be a witness, that part of the will is void. They get nothing. They witnessed it, okay? It changes the outcome of the intention of what you're trying to do. So definitely want to do it properly. I mean, you've got the power now to do these documents, so use it wisely is really my advice there. So trust. A trust is something that you can create and put your property in. It's much like creating a business and then titling all your property in the name of the business, okay? The business bank account, the business real estate, it's the same idea on a trust. I recommend to people that if they're going to do a living or revocable trust, that they get some tax advice related to that before they do it, that they consider the numbers, the pros and cons. I don't do revocable living trust because it's not a part of the clients that I'm serving, but it is something that I often refer to people to a tax attorney for it. I do meet a lot of people who read about it online, and they're seeing it on the internet. Everybody's saying you need a revocable living trust to avoid probate. There's a lot of other things you can do to avoid probate, and there is a place for that, but I think it's a very specialized place. And I think there's a kind of a whole nother layer of education you want to have about what you're getting ready to do. I think one of the saddest things I see is when people come to me and they have this whole plan, somebody set up this very expensive trust plan for them. They never put any property in it. They just created it, put it in a 3-ring binder, and it looks really like a lot of planning. There's not a single asset in there. It's just the paperwork, and they don't really understand what they have. So anyway, I recommend doing some extra consulting before you go that route. Very useful in the right circumstances. And then the last thing I put up here is legal rights of spouses and children. Spouses and children do have some rights if they are left out of wills. Spouses more so than children. After-born children, let's say you did a will before you had that child, there's an argument that child can raise if you never updated your will, okay? Spouses who, let's say you did a will and then you got married, that spouse has a claim on your estate. If a spouse is left totally out of a will, that spouse can have a claim on that estate. I think when you get into let's say second marriage situations, those can be quite complicated. So I recommend people get some individual counseling on what is it you're trying to accomplish, and does the law let you do that, or does the law protect those people anyway? But especially if you're not trying to benefit your kind of natural objects of your affection, your spouse and children. That's difficult, but can be done, but needs to be looked at carefully. Okay, so documents you leave behind. I'm kind of going to move through a couple of these slides because I've really covered them. Let's see, we talked about the will. And I want to mention here a personal property memo. So a personal property memo is something that you can authorize in your will. So right now, if you don't have a will and you just go get a pad of paper and you say, I want my blue vase to go to my cousin Nancy, I want the picture over the mantle to go to my brother John, well, that has no legal impact. Your family might follow it out of respect for you, but it has no power in that document at all. But if your will you authorize yourself to leave a memo like that, then that memo has the same power as the will if it's found and if you signed it. No witnesses are needed, no notary. You can have multiple personal property memos as your personal property changes over time. So that's a really great thing to do, especially if you have something that doesn't divide well. Had some clients one time who had their mother, 3 daughters, their mother had won a bracelet on The Price is Right. You could not divide that. They could not, there was no way to divide that thing, and it caused a lot of heartburn. If you've got some things that don't divide well, putting them in a personal property memo is a great way to settle the issue. You decide what equalizes that for the others. You know, if you've got 1 diamond ring, okay, well, it's got to go to somebody, and how is that going to be equalized? Are you going to leave that up to them to fight it out, or are you going to go ahead and decide that? I recommend going ahead and deciding that, if you can, for things that don't divide well. So that's the will, and hopefully a personal property memo for anything you want to do that with. All right, and then I'm going to just kind of mention this. This is on the back side of your flyer, and we've hit on some of these documents already, but there are some legal documents that you have and have the opportunity to do that really affect, they have power now during your life, and they have power later after you're gone. And those are your deed. We talked about that right of survivorship, a title to a boat, a motor, a car. If you're going to jointly own anything like that, you want to be sure it has that or between it and not an and. Because having to go through the probate process for just a half interest in a car, you know, people look at me and they're like, why did nobody tell me this? This was an easy fix when we first bought that car or boat. Beneficiary designations, making sure they're up to date, and then a trust is also mentioned there. Things that change the ownership during life and affect the ownership after you're gone. Okay. Let me skip here. All right, back to this idea of passing things non-probate. Let me be sure. I've really put this in here to be sure there wasn't anything I had skipped before. Before I go on to just some general rules for signing legal documents, do I have any questions from you guys about passing property from yourself to beneficiaries, anything to do with these types of non-probate options? Yes, ma'am.
I have a question, and it deals with the and or. So say you have a vehicle, and it's paid off, and it's and, how can you change it to or if need be? Same thing with
Sure.
the house or, you know.
Okay, so for the question for those who are online was that if you have a vehicle, car title, and it says and, it has both names, Jack and Jill, and you want to change it to or. So you take the title to the DMV, they'll show you which form to fill out, and you're basically transferring and requesting a new title at the same time. You're transferring it to yourselves in or. You both have to sign the form, but you turn in the title and then you get back a new one that has or. You can do it in one visit to the DMV and they will get you the title. It's a little more difficult if you have a lien. If you have a lien on the car, the lien holder is holding the title. So you've you've got to coordinate with them to get that done. I have had clients just say it wasn't worth it. They tried and it wasn't worth it, and others, you've got someone helpful on the other end of the phone, and we're able to accomplish it. But that's how that will work.
So with the deed,
So a deed, to add the right of survivorship to your deed, you have to actually convey the property to yourself. So you do a new deed from Jack and Jill to Jack and Jill as joint tenants with the right of survivorship. So it gets recorded in the Register of Deeds office, and you just deed it to yourselves. Yes, ma'am. If you move counties, it's still valid, but I recommend that you record it also in your new county of residence. It gets difficult if you move a lot, because when you want to cancel it, you need to cancel it everywhere you recorded it. But it can be recorded in multiple counties. All right, you get the original back, and then you can record it in another county when you move. You could cancel it in the prior county, but as long as you're not changing your mind, that's not a problem. What we do when someone has recorded a power of attorney in 2 counties and now they're doing a new one is we'll record the new one, and then we'll record revocations to revoke in both counties before. Okay? Anything else? All right. Let's see what I've got here. I might be, there we go. So, some basic rules for signing legal documents. Any of these types of documents that we've talked about. Competence to sign legal documents. It might involve a medical opinion. If someone has a diagnosis of dementia, someone has, the family members are saying they don't remember, things. Maybe they don't have the diagnosis yet, but there's some concerns. The threshold of competence for all these documents is a little bit different for each document, okay? And I really recommend that you not put this off, because when there's a question about competence, then it does involve, sometimes we will schedule an appointment right after they're leaving the doctor's office, and they come to my office with a letter where the doctor says they think this person is competent to sign a document, and we document the file that way. But lack of confidence casts doubt on the document, and so you don't want to wait on that. Correct all spelling errors. When you are looking at a document, especially true for names, I had one where there was a will contest after someone died. A person who was not happy with what the will said brought a contest against the will, asked the court to declare that the person must not have been competent, must have been sign anything that put in front of them, because their son's name was spelled wrong. And so clearly they didn't read it. They might have read a lot of it, and I wasn't the lawyer I was the lawyer in the probate, not in the estate planning, but I tell you that story because if you don't read it and don't bring up even obvious things, it can cast doubt on the document. Read and understand it before signing, and understand how the document itself is going to be interpreted. So, wills are interpreted from the beginning to the end. The order in which things appear in the will is important. So if at the beginning of the will there is a bequest, a statement that says, I leave $100,000 to my brother John, and then I leave the rest to my sister Nancy. Well, at the time you make the will, that might seem like maybe that's just a portion, maybe that's just a 10%, right? But then by the time you pass away, there's only $80,000 in the estate, everything goes to John, right? It was in the will first, ahead of the part about Nancy. The first part went to John. So whatever is going out first at the top of the will, when you get to the later provisions, if it's already gone, it's too late. That you can't come back at the end and say, oh, but only if. It's going to be read in the order in which it's stated. Percentages are a good thing to do in a will to avoid that scenario I was just talking about, where you think you're making a gift of about 10% of your assets, but your assets are constantly changing. So if you pick a number, it may end up being 50% of your assets instead of 10. And so a percentage is a good way around that, and you can do that in a will. Powers of attorney, another way when we talk about how these documents are going to be interpreted, they're strictly construed against giving power. All right? They only give what they say they're giving. So understand that when you're signing them and reviewing them. I recommend reviewing and updating your documents about every 5 years, but that's really arbitrary. Certainly if you move states, I think switching states, the law that applies at your death is the law of the state of your residence. So if you switch residential states, that law is going to apply. Now, we do recognize wills that were validly executed when in the state they were executed in, and vice versa. That's true across all states. But reviewing it if you have death in the family, changes in assets, and then make sure your loved ones know where to find your important legal documents when you're not around to tell them. Whether it is you're in the hospital or whether it is you've passed away, do they know where to look to find those documents? So that's really important. I want to talk just a minute about protecting children and minors. I don't have a slide on this, but in wills, most wills now will contain a testamentary trust. A testamentary trust just means it's created in the last will and testament. Okay, that testament word again. It's created, it says, if a beneficiary of this will turns out to be under age 18 or under age 21 or under age 25, so it's a if, then I want a trust created for them in the future when that happens, so that it's held in trust for them until age 18, 21, 25, whatever it is you say. That is a way of keeping, because children cannot own assets the same that adults can. Now, they can have a necklace, they can own some personal property, but they can't have a individual bank account or stock in the stock market or real estate. Okay, so you don't want to be leaving those assets to minors, but a will can protect them. And that is one instance where probate is actually a good vehicle in many instances for getting property to children or young adults in a protected manner. Or if someone has special needs or disabilities and you don't want, they don't need the asset directly in their hands, or someone may be disabled in the future, then the testamentary trust can protect the beneficiary that needs that protection. Think about it this way. If you've got life insurance and you name your minor grandchildren as the beneficiary, and they're little children, okay, when you pass away, that asset needs to go to those little children, and a conservatorship will have to be set up in the probate court. If it's some significant value, it could be an expensive process. Whereas if it went from you through probate, you've got a will setting up a trust for those children. Some life insurance and financial vehicles, investment accounts, you can name a beneficiary to be the testamentary trust created in my will. But that's a kind of planning that you need to think through. If you're trying to benefit minor children or people who have disabilities or special needs, it's just another layer of thinking through it, because you don't want to put the asset right in their hands. All right, any questions about kind of how the documents are read, terms that can be in a will, how to protect certain kinds of individuals? Say what? Oh, thank you. Thank you. Well, I use my hands a lot. I'm glad I didn't grab the microphone and throw it while I was talking. I'll be glad to answer any questions afterwards that anyone has, and I really appreciate your attention, and I hope that you feel better armed to go through and say, yes, either I've got these things in order and this confirms what I thought, or maybe I raised some questions that you want to do some further looking into to get things in order. But it's a gift to your spouse, to your loved ones, to your friends and your family when you have these things in order and then they need to carry them out. It's a real gift. And people think, well, I don't know, I don't want to talk about death, or I don't want to talk about illness. Having had the conversation, they will remember it as a gift. So I just encourage you to go ahead and have those conversations. So, great. Thank you.
All right. Thank you, Lisa. That was very informative and very helpful. I really appreciate what you said. Also, keep in mind, I know there's a lot of information. You know, this is on Union Live, so it is recorded. So feel free, you can go to our Union.org, to the website, look at sermons, and you'll be able to find the seminar there so you can review it. Friends and family that you think need to see it as well, invite them to go to the website as well so they can see it. And Miss Lisa is available, so she passed out some information, has her contact. Keep in mind, she is Lisa Lee Smith, and she is in Chapin, so don't get her confused with the other attorneys that around may have the same name. So, but I appreciate everybody that came out today, and I really appreciate you showing up and explaining all this to us. Very helpful. Thank you.